Hello, good evening. Welcome to UPFront. Tonight, the Atuforcing Ambulance Court has admitted audio recording involving the Attorney General and businessman Richard Jakpa, who is also a third accused in that particular case. The recording's admission is aimed at ensuring fairness, countering the Attorney General's objections, questioning its foundation and relevance. The controversy originated from lawyers representing Mr. Jakpa and also the minority leader attempting to introduce the recording, arguing it is vital to the charges of causing financial loss to the state. Atuforcing's lead counsel, Dr. Aziz Bamba, has been contending that the AG's conduct in the recording suggested procedural irregularities and suppression of the accused, implying the case was not pursued in good faith, despite the AG's argument against the recording's relevance and the assertion of privacy violations. Justice Fiasewa Asariboche admitted it into evidence. Tonight at UPFront, we'll explore what this really means for the case that's currently before court. But that's not just what's been happening in that particular case. Before we bring you the latest happening there, you did hear Mr. Jakpa raise some other issues when he actually mounted the stand once again to be cross-examined by Mr. Forson's lawyers. Some of the things he's been saying is that he's been detailing a WhatsApp conversation where the Attorney General is alleged to have requested him to spy on the second accused who has been discharged in this particular case. He is a former chief director of the Ministry of Health. We are also talking about accusations that the AG has been having political motivation, stating that the AG aimed to conclude the case before the general elections and that he felt that if the case was concluded in May, there would necessarily be some by-election ahead of the main election. He's also been claiming that the Attorney General has been discussing plans to financially support a campaign to win the seats of the minority leader in Parliament. That's Kasiel Atuforcing. Now, what he's been saying includes expressing frustration over broken promises by the Attorney General regarding his discharge. And we are talking here about Richard Jakpa's discharge for cooperating with the Attorney General. He's also been saying that Dr. Forson's prosecution is politically motivated. And this is not the first time he's made this accusation. He's been describing how he cooperated with the Attorney General based on some false assurances in court today, and much of that has been happening together with dismissing claims that the ambulances, which is at the center of this entire trial, were unfit for purpose as politically motivated sabotage. That is how he described it in the court earlier today. He's been recounting a conversation with the Attorney General, Godfrey Adami, seeking his cooperation. He's been detailing requests to withhold certain information in court to avoid some complications. He's also been narrating an incident at Justice Yoni Kolende, who is a Supreme Court judge anyway, in his house, where he encountered the Attorney General unexpectedly, leading to a panicked reaction. Mr. Jakpa's testimony, it depicts the prosecution of Dr. Forson as politically driven and influenced by external pressures rather than genuine legal concerns. All of this he's been saying in court under oath when he was being cross-examined by the lawyers for Kasiel Atuforcing. We will be exploring the bigger development today, what the admission of that particular tape into evidence means and what it means for a case that's traveling down the line, has gone through a lot of rigmarole in terms of what the public opinion is on this and what's really happening in court. And of course, it was adjourned after this cross-examination by the very representatives of Mr. Kasiel Herford of Richard Jakpa, who's been saying the things I've detailed before you. Pretty soon, I should be able to bring in lawyers to help us understand this. But this is not the only thing happening now in the Parliament of the Republic of Ghana. You heard the earlier indication by the minority in Ghana's Parliament that whenever the case was called, they were going to rather support the minority leader than be in Parliament. This is an issue that's become thorny. Later on in the show, we should be exploring that. But first, we should be able to get to understand what's happening in Parliament on these matters too. After this break, we should come to break down what really happened in court, plus what's happening in Parliament, and then explore whether or not the minorities' conduct is fair to their representatives? Welcome back to our front. And tonight I've been telling you about what's happening in the courts of the Republic of Ghana, where there appears to be the decision of the judge, Efia Sewasa Iboche, in the Atufosi case to admit that tape recording of the third accused, Richard Jakpa, with the Attorney General of the Republic of Ghana. That conversation became controversial a couple of weeks ago, and yet the judge has found it worthy of admitting that. We'll be exploring what that ruling means for the case going forward, and also be talking to some very distinguished lawyers about what's happening in the case substantively, as in to do with the decision by many people within this particular spectrum as a minority to actually basically boycott parliamentary proceedings when the case is called in the courts. We'll also be telling you what Richard Jakpa be saying in court, including his claim that he was asked to spy on the second accused who's been discharged. That's the former chief director of the Ministry of Health. All of that happening now. But first, you sure would know by now that the minority in Ghana's parliament has been threatening to boycott parliament over the trial involving the minority leader. I mean, the minority caucus expressed their unflinching support for the minority leader throughout the trial. In fact, they have been insisting that they will not be available for business of parliament and will only be available after proceedings of the court have ended on the days scheduled for the hearing like today. And of course, we did not see many of them in the courtroom as was reported to us. But this issue is of importance because this is not the first time it's happening. We do know that in the case of Richard Kwesi, a similar decision was taken later on abandoned. Let me explore that with a man who understands parliamentary procedure and the democratic elements expected of representatives in parliament. Dr. Rashid Draman joins me now. He is the Executive Director of the Africa Center for Parliamentary Affairs. Doc, you're welcome to our front.
Thank you. Good evening.
Good evening. Doc, let me start on the basis. I mean, this is not the first time. MPs have boycotted parliament when they felt the president was not even legitimate. They have boycotted parliament when they felt they had difficulties. But this is about a trial in a court of competent jurisdiction involving the minority leader. Is that a justified reason to boycott parliament?
First of all, let me maybe start by saying that globally, parliamentary boycotts, research has shown that only about 25, so a quarter of all parliamentary boycotts have had the intended effect, which means that I think about 75% of all parliamentary boycotts across different jurisdictions have not yielded the intended results. At the bottom of it is the fact that we need our members of parliament to participate in the democratic process, in the deliberations in the House. You are absent, maybe on your blind side, some very important issues will be discussed, and you will not be part of it. And your constituents would, not get the benefit of their being represented in the House. So for me, like you indicated, we've been here before. We've seen boycotts in the past. In the end, whether it's NDC or MPP, they've ended up abandoning that and coming back to the House. So for me, I think, look, there are two ways of looking at this. You want to solidarize with the leader. I think, some members can be delegated to go solidarize with the leader anytime he is in court. On the other hand, can we have the judge looking at this maybe on days that Parliament is not sitting, so that, we give the benefit to the leader of the minority caucus to be in Parliament group. I'm not a lawyer. I don't know all the intricacies of the proceedings and so on. But I think at the end of that of dilemmas that affect all of us in the country, because we need our MPs in the House. These boycotts, one way or the other, they have not been successful over the years. If you go out of the House, you don't get represented properly. So at the end of the day, I think there's a need to say that maybe threaten but participate. And they have to find a balance between this, the threat and their participation in the processes of parliamentary.
Now, it appears an interesting development for a simple reason. Mostly, they would say the trial itself is unjust and everything connected to that. So this is expressing their opposition to it. But today's own appears very peculiar, which is there was a request, and this is what the minority chief whip actually put out there. That's Kwame Govins Agboja. The request for the court's permission to allow the minority leader to participate in significant minority activities on Tuesday, June 11, coinciding with the resumption of the House's third meeting, was not allowed. They believe that the minority leader has very relevant roles to play in Parliament, and that if the court could come to some consensus on when to sit, so that it doesn't disable him from performing his role as leader of a major caucus in Parliament. Is that, on the face of it, too much to ask?
I don't think that it is too much to ask. Look, I mean, this is, on the one hand, a legal process, but we also have to see it as a political process, especially because, we are in a dispensation where we have a hung parliament. We are in a dispensation where we have, the two parties with equal numbers. And June 11, I think, was the first day of Parliament. And both leaders have a very important role to play. So if the minority asks the judge to allow their leader please some little time to come and represent them, make his clean statements and so on, from where I don't think that this is too much to ask, especially if we think about it not simply as a legal process, but also as political issue. And I believe, the lawyers would tell all of us that what jurisprudence, some, other considerations are brought to bear when dealing with the law. That is not just necessarily only.
On the other hand, there are some that have said these are representatives of the people, and that the member of parliament for Infansman, for example, cannot be seen solidarizing with his colleague MP to the detriment of the role he's supposed to play for and on behalf of the people of Infansman as a delegated representative.
Yes, indeed. That's why I was saying at the beginning that perhaps, they have a role to show up and work. They have an important role to participate in the proceedings. How do you do this while at the same time solidarizing with your leader? So a balance needs to be struck. Who goes with the leader to court and who stays in the House to participate in the business of the House, especially on the back of the data that I was sharing with you earlier, that, research has shown that only a quarter of these boycotts usually get the intended effect. So, yes, you and I, we all have the right to be represented in Parliament, and when our parliamentarians abandon their duty to accompany their leader, we are being shortchanged. At the same time, they also have a duty to solidarize with the leader because he's also a political person, and we have to understand it as such. How do you strike the balance? How do you make sure that you don't alienate yourself as a representative from your people, whilst at the same time, making sure that political group, whatever position that group takes, at least that position is at edge one way or the other. So it's a bit of a dilemma, Raymond. I think for me, I want to go back to what I said earlier. I think this is a legal process, but it's also a political process. We have to think about it in that sense. The Attorney General, all the, judges. But you see, the other issue is what you raised earlier. With all these tapes and what we've all heard, we heard the voice of the Attorney General and all those. I mean, many people are saying, there is something that is not right with this. There is something that is not true just about this. Based on the things that we have all heard, people have different conclusions. And so I think that is why we handle very carefully, so that judges don't give credence to the fact that this is not a legal process supposed to bring justice, but it's just simply maybe trying to pick on the leader of major party in parliament.
The people who referenced the judge's very first comment in court about this matter say it was so clear. She was insistent that nobody can use an excuse of a parliamentary proceeding to not necessarily attend court. Some say it's basically a clash of two arms of government and the expectations of parliamentarians in parliament, and also the courtesies that are supposed to be extended to, say, a minority leader or any other person at all when they are attending upon a court. Can these be dealt by the people that run the various institutions? And I'm talking about leadership of parliament versus leadership of the judiciary at some point. So we do not have to choose between a leader attending parliament or doing critical work, which comes with living with these people, which really will affect the kind of work that's expected of them.
Yes, indeed, Raymond. The issue here is just like many other cases that we have seen before. You remember the issue of the LGBTQ and how the Right Honorable Speaker, somebody went to court and then they refused to, consider the appointment of ministers who were nominated by the president and so on. I mean, at that time, some of us said, look, this would not be resolved by the law, to be resolved by politics. And I think in this particular case, I believe this will not be resolved purely by law. I mean, there has to be some politics in it, and I think you have touched on it. I mean, the leader of parliament, that's the speaker, I mean, the leader of the judiciary, the chief justice, and I believe maybe the attorney general representing the president or the president himself. I think, some conversations would need to take place. Because if you stretch this and think about, look, sometimes somebody has to go to court, but they say, I have a medical appointment, I have a doctor's excuse and so on, and because of that I cannot attend to court, and then the court grants that permission. I think we can consider this in the same vein, particularly if the minority is saying, we want our leader to be present on the day that Parliament is resuming, so that he makes a statement, delivers a statement on behalf of the minority and so on. I don't know whether this is too much to ask, especially because we've seen instances in other criminal proceedings when people are given the permission not to attend to the court because they have maybe medical appointments and so on. So I'm saying all this, Raymond, not from a kind of legal perspective, because I'm not a lawyer. So
yes, of course.
I might be offending the law, but at least I'm just saying this from a common sense and from a political kind of perspective.
Would it be fair for a deputy minority leader to say, step in and play the role of the minority leader? Especially mindful of the numbers game they play in this kind of parliament.
So you see, that's the point I'm making. I've been intimately kind of related with this parliament as well as other parliaments before. And I know there are instances when, a lot of negotiation takes place, especially in this particular parliament because of the numbers. So there are moments when the majority side wants the cooperation of the minority side. And if we are going to see some of these moments, I mean, in the rest of the lifespan of this parliament, I think that calls for some kind of political approach to dealing with this matter.
There are those who say that the constituents of the boycotting MPs should punish them for failing to perform the role they have given them. Is that a realistic, reasonable expectation?
Well, I think there are so many factors that constituents take into account. When we go to make our decisions, and I don't know whether if I would rather say, we've had several instances when MPs did not show up for work for no reason that we know of. I would support those who say in these kind of instances they should be punished. But I think in this particular matter, there are so many variables, and to just be difficult to say just because they are solidarizing with their leader, they should be punished. They have to show up and work. As for that one, I think there's no doubt about that. But I think there has to be some reasonability in handling this whole case. We are not also saying that if the leader is guilty, anybody who is guilty in this country of breaking the law, Parliament made, that person should be made to pay for it. But I think there are many other variables that need to be taken into account.
Very well. In the hypothetical situation, Dr. Draman, in the hypothetical situation where the court sits for 15 straight days, mindful of the rule in Ghana's parliament about absence for 15 days and beyond, would it count as one of those ways where you have abandoned your role in Ghana's parliament and ought to be penalized for it?
Maybe this particular case is different because everybody knows that the leader is in court, and I'm sure maybe he does the needful, or his office does the needful in terms of notifying the Right Honourable Speaker that he's in court and so on, or because it's public knowledge that counts as notice to the institution. I don't know, but absence, I think 15 continuous days, means that you have abandoned your seat. But let me be quick to add that Parliament has been toothless over the years in terms of dealing with this matter. We haven't seen Parliament in its strength dealing with this matter. We saw what Honourable Jakpa, saw what happened to Honourable Jakpa, we saw what happened.
And I'm afraid I appear to be losing you. Yes, I'm struggling to get the words from you. You were trying to mention some members of parliament, but I wasn't sure whether I got it properly.
Can you hear me now?
It's absolutely fantastic, sir.
Yes, I was saying that when it comes to punishing MPs for absenteeism, this parliament, as well as all the parliaments before, have been very weak. They haven't been able to live up to that expectation, because we saw what happened in the case of Honorable Ajwa. We saw what happened in the case of Honorable Kennedy Japan. We saw what happened in the case of current Minister for Interior. I think they were summoned before the Privileges Committee for absenteeism, and so in the end, I think we don't know what to that case. They are still members of Parliament. So I was just adding that dimension.
Okay.
Yeah.
Well, I'm grateful to you for your time this evening, and I am very grateful because you joined us to share some thoughts with us on this particular development in the Parliament of the Republic of Ghana, when the minority had indicated that on the days they were supposed to be in call solidarizing with the minority leader, they would once again not be available for parliamentary business until that business is done. Dr. Rashid Rahman is the Executive Director of the Africa Center for Parliamentary Affairs. When we return from this break, we should be able to take you straight into the courts, break down what really happened, what things has Mr. Jakpa been saying about that controversial engagement with the Attorney General of the Republic of Ghana after the courts early on admitted the tape recording that has generated a lot of controversy in the Republic of Ghana. After this break. You're welcome back to UPFront. Now, it's that particular case that panned out in court earlier today where the Atuforse Ambulance Court admitted the audio recording involving the Attorney General of the Republic of Ghana and the businessman Richard Jakpa into evidence. Of course, the recording's admission was aimed, according to the court, at ensuring fairness, countering the Attorney General's objections, questioning its foundation and relevance. I've been joined on the Zoom by a lawyer who understands some of these things. Mr. Pegbu Martin, I hope you are doing well this evening.
Mr. Akwa, good evening.
Yes, let's start from the basis. Some say exactly what is the import of having to admit such a tape, mindful of the most recent ruling, which basically dismissed all the 4 pleas that were submitted to the court.
Yes. What, Mr. Akwa, what will happen is that, you see, though the tape had already been largely dealt with, it is the case that admitting it in a way erodes the case of the Attorney General. Why do I say so? It shows, so it means that it takes a lot away from the case of the Attorney General. Now, why do we say so? It shows that this is an Attorney General who doesn't believe in the strength of his case and is now suborning witnesses. The Attorney General is suborning witnesses. You see. So once the Attorney General is suborning witnesses, then you're like, it means that the Attorney General doesn't believe in his case. So credibility issues. With this tape in, listen, this case, that's the Atuforse case, is one that will forever taint the office of the Attorney General. So that's a collateral purpose. But the immediate one, as you're asking, that people are saying, what do they gain? What is gained is that it shows that the Attorney General doesn't believe in his case, so he had to go suborn witnesses. And so that should have a huge effect on the case. You will hear him negotiating with Jakpa to answer in a manner that suits Godfrey Dame, contrary to the opinion of Jakpa that, Godfrey Dame, the way you want me to answer will hurt my integrity, that it is dishonest, blah, blah, blah. So for that effect, look, even if ultimately, touch wood, the court were to find Atuforse and Co. guilty, this tape takes away everything from the case. It takes away everything. It shows here is an Attorney General who is very much interested in underhand dealings to be able to win a case, suborning witnesses. It's no joke. If you believed in your case, you wouldn't go see a witness and coach him. Look, the last time such a thing happened in the Supreme Court, I think in the case of Vivian Akudankwa and Odati Sro, yeah, the Supreme Court commented. So one of the parties, the Odati Sro people, were said to have gone to see a certain witness and then try to get him to come and testify in a certain manner. The Supreme Court didn't look kindly at all on it. The Supreme Court didn't look kindly at all on that conduct in the Akudankwa case, okay? So similarly, that tape casts a very long shadow over this Atuforse case. Look, trust me, the Attorney General was supposed to have entered a nolo prosequa to stop this case the moment the tape came out. Then it would have been a matter of speculations here and there. And then after a week or two, it would have gone out. But now this tape has been admitted officially. You remember, Besakwa, that the, what do you call it? The MPP came out and said the tape was doctored and did Nana B. And then you hear senior lawyer Frank Davis and all those people. They made all those statements at their press conference. Now this tape has been admitted. Can you imagine how it erodes their credibility? They themselves, so now they will suffer personally. And also, as I said, officially, once the tape is being admitted, then it means that officially, the contents can be used against the office of the Attorney General. It's not just Godfrey Dame and those yet to come. So you see why we kept saying that, look, Dame was just supposed to stop the trial by entering a nolle prosequi. Then the rest, it would have become, what do you call it, a matter of speculation.
But
the issue of,
is the court not now expected to make a finding as to how damaging or its impact at the end of the trial?
Yes, but what I'm saying is that even if the judge is done, it doesn't take away the right of citizens to also make their analysis. Just like, look at it, you remember in the application, the judge did her analysis, and citizens are also doing theirs, because what concerns the citizens most, which is the part where Godfrey Dame is coaching the accused witness to answer in a certain manner, the judge wasn't interested, but citizens are interested, and I'm also included being interested in that part, because that is the kernel of the matter, where you're saying, oh, answer it this way, it won't do anything to you, blah, blah, blah. That is the heart of the matter. And that's why I'm saying that, so this is a tape that people will analyze for decades to come. Okay. When we are dead and gone, this tape will continue to be analyzed. So you see that the damage to Ghana, Ghana as a nation, is incalculable. Now, it will continue and continue for decades and hundreds of years to come.
The case continued. Yes, I can. The case continued, and the Attorney General actually was accused of calling Mr. Jakpa to spy on the second accused who has been discharged, that is Mr. Animana, to verify if indeed he was at the hospital. Indeed, in the words of Jakpa, he did the work and replied at 8:48 on the 23rd of November 2023 to the Attorney General and said, and the Attorney General finally said thanks. He told the court that when he actually opened WhatsApp conversations and all of that was put out there. Now, the other things that he's been saying the Attorney General got him to do, some that sounded a bit strange, as in detailing a WhatsApp conversation where the AG requested him to spy on Mr. Animana. He's also been accusing the Attorney General of political motivation, stating that the AG aimed to conclude the case before the general election. To many people, these are alarming statements, but of what merit is such detail in a proceeding like this in court?
It's of great, substantial, and immense merit in different perspectives. As I've said, now that he says Dame was just looking to take Atuforsen's seat, etc., right? Mm-hmm. The judge will be analyzing it. When it is the turn of Dame, and I hope it's not Dame, the turn of the Attorney General, and I hope that by that time, Dame should have left office, because it's the case that he has to leave that office. Godfrey Dame is not fit for that office. He has embarrassed us too much. He's committed too many ethical breaches, and the criminal cases will be taken up against him when his government leaves office. So Dame must be out of that office. And he should be followed by Tia Ebua, because Tia Ebua has shown that he's an enabler, okay, through his responses.
But in all fairness, the Attorney General, as we speak today, there's not been any successfully proven case against him of misconduct or any of the other things. That's factual, right?
Oh, but you heard the tape, partly. Things have been proven against him.
I agree, but...
Let me say, in the ruling, it's for me to say. Yeah, you can also give your side. In the ruling, the judge said the conduct of the Attorney General causes discomfort and discomfiture. Discomfort and discomfiture. And not just once, not twice, 3 different places. At another place, she said it was discomforting, etc. And then ended up by saying Dami should stay out of that case. That is not a joke.
An advice.
Have you ever seen that?
An advice.
Have you ever seen that against any Attorney General of Ghana?
I've not heard, but this was an advice, and he dismissed the advice. He moved on to do the case.
Because that's his character. So it just shows that he doesn't even understand the import of that advice.
And we are talking about the Attorney General of the Republic of Ghana, in all fairness.
Yes, but who is the Attorney General? He's our servant. The president serves us. The president is to serve us with his ministers. That's the problem we have in Ghana. We tend to rather serve the people who we've employed to serve us.
No, I was just saying that he's the leader of the bar. That's without doubt, right?
Yes, so but he's our servant. So let's go on. So what was the main question?
No, the question I asked is, there are so many, if you want a proper term for public notice on it, interesting things that are being said by Mr. Jakpa today. Of course, he has not been cross-examined. Many people have started making their minds on what they want to do with that already. But I'm asking you as a lawyer, should we wait for him to be cross-examined? Should we wait to hear what the judge will say about all of these things finally, or people can make up their minds on it?
The last one first, but all of them, all the questions you've asked, yes, yes, yes. Yes, so people can make their minds up already. Yes, that we should wait for the final say of the judge. And yes, wait for the cross-examination. So it's yes, yes, yes. Okay, now let's go over a bit in detail. Now, we can make up our minds because once we've heard that, you're like, when was the last time you heard a witness say that about an Attorney General? And especially on the back of a tape that's been admitted. So meaning that the conversation took place, it means that the Attorney General met the witness/accused person in the house of Justice Yoni Kulendi, and that the Attorney General tried to get the witness, coach him to answer in a certain manner. So those are feeding into the further evidence that Jakpa is giving, and rightfully so. So we cannot, in that sense, say we'll wait till the judge is done. No, even when the judge is done, citizens have a right to form their own opinion. That's the nature of a democracy, right? So we are totally damaged. No judgment can wipe off this. No judgment can wipe off this. People have heard Godfrey Dame asking the witness to skew answers, asking the witness to mislead the court, after the witness had given him good education on the meaning of a site LC. You see Dame being adamant and saying, no, you answer it my way. It won't cause you any harm, etc. And we are joking with this. I'm not being because President Kufuor himself is so corrupt. Dame wouldn't have been in that office. Dame wouldn't have been in that office past 24 hours when that tape came out.
Martin,
but, we've sunk so low.
Is a lawyer, and I'm grateful to you for your time this evening. Forgive me, my time is up. I am grateful to you for your time this evening. Ladies and gentlemen, that's where we tie the nice ribbons on today's edition of UPFront. Many thanks to you for watching.